The following is a legal advertisement. This does not constitute individual legal advice and should not be construed as such. This podcast is for informational and educational purposes only.
Hi, I'm Gwendolyn Sterk, and I'm here with Margo McDermed, our state representative where our office is located. And we're here today to talk about the decision-making process of when appellate court decisions are in conflict or need to be changed. What is the right and what is the balance between the appellate and Supreme Court of Illinois' decision-making and the legislative authority? Margo, I know that this seems somewhat complex, but in explaining to clients over time, you might have the body of what we call the IMDMA, which is the Illinois Marriage and Dissolution of Marriage Act, and then we have that interpreted by a body of law, which is contained in appellate decisions as well as decisions made by the Illinois Supreme Court. And sometimes for individuals hearing that, they become somewhat confused about how that process works. So perhaps you can tell us what the legislative role is versus the court role within that context.
Well, we have to go back to civics class, Gwen.
Sure, I know.
You know, here in the United States, the decision has been made from the very beginning that we have, three different parts of our government. We have the executive, in the case of Illinois, that's the governor, or in the case of the United States, that's the president, and we have the legislature. In Illinois, we call that the General Assembly, and we also have our court system, and we have, the different appellate courts, and in Illinois, we have a Supreme Court. And so the role of the legislature is to create laws, to pass laws based on our representative roles. In other words, people tell us, this is what we'd like to see, this is how we want our society to be, and we try to bring those ideas forward in our role as representatives. So I go down to Springfield representing the people in Frankfort, Mokena, New Lenox, Tinley Park, Orland Park, Homer Glen, and speak for them about how they want their lives as an organized society of the state of Illinois to be. And then it's up to the judges to make decisions about how those laws have played out and
how they get applied, right?
Right, how they get applied.
Okay, but let's say hypothetically, or in some instances, that's what happens, is people say, well, the legislature provided this law and it doesn't provide for this interpretation, and what would you do? So how do you look at that? If an appellate court, do you believe that the court has then the decision to interpret the law?
Well, it's always been the role of the courts in the United States in general, and Illinois in particular, to interpret the laws. That's their job, is to take this particular dispute between A and B and say, this is how the law applies in this case. And that's their role, and it's not for the governor or the legislature to say, you can't do that. If we don't like it, our remedy is to say, we're going to make another law.
Okay, so yeah, because that's really the case. So on the law doesn't provide for X or interpret how long. For example, we had talked previously in a podcast about how long the maintenance laws would be in effect, and the legislature says it's permanent maintenance. So then the court says, well, if it's permanent maintenance, how long does somebody have to work? So maybe the different decisions are there, and what's good faith retirement and what's not might have different opinions between different judges, and in fact could have different opinions depending on different appellate courts, because we know there's different districts in Illinois. But if the legislature said, wait a minute, either we don't think that that's how the law should be, or we didn't address that, but we feel that the people would want us to address it. The legislature, just so that I'm clear and understand this, and that people listening understand that the legislature could then create another law to overcome kind of that appellate decision. Would that be a fair statement?
And yes, that's a fair statement, and that happens. Laws have changed.
And laws might not fit all. You can't anticipate everything, fair?
I think we'd like to think that we're great and wonderful and all-seeing as the legislature, but we know that's not true, and sometimes there are unforeseen consequences, and society changes. Remember when all divorces had to have a grounds for divorce?
Right.
And, so as things change, as society changes, as what is happening in the world changes, as technology changes,
absolutely.
we need to respond.
Right.
And perhaps there are, when there's a number of different judicial districts with different opinions, it may be that the legislature needs to step in and say, we're going to have one way of doing it, or at least we're going to start it all over again with one way of doing it.
And that's really what we've recently seen in family law, because starting in 2015, we had the maintenance laws go into effect, and then by the time the year 2016, we had major modifications to Illinois Marriage and Dissolution of Marriage Act. We had major changes getting rid of the concept of custody, going to parental allocation, and then in 2017, we've had the child support laws. So that really was an act of the legislature, correct, to move forward and overcome that case law and deal with what society changes had occurred.
That's exactly right. So we can't tell the judges what to do, but we can go ahead and change the laws on the books in Illinois.
So if somebody is unsatisfied with a result in a particular case, they have the right to go before the judge, have a trial occur. If they don't like the decision, then the appellate court would review it, and in some limited cases, the Illinois Supreme Court may hear their case on those particular facts. But that would be case-by-case specific, correct?
Correct.
Contrary to that, so I'm clear, when you go through the legislative process, that is a more general body of law, meaning that it would be applicable to all the cases that would come before and not a particular set of circumstances.
Right. It's not even permitted to make law for one specific case.
Right. And so as a general rule of thumb, if somebody wanted to effectuate change, the change would be for everyone. The process is different through the appellate court process would be your individual case, and the legislative process would be for the evolution of the laws as a whole as they affect the individual. Correct?
Yes, for all the cases of people that are in those circumstances.
And so then it becomes an interesting question, and one of the things that we've seen over the last couple of years is, for example, we have new maintenance laws. Does the old body of appellate decisions apply still, or does the new law require that we have new interpretations? So that's an interesting problem as practitioners, as lawyers we have.
Yeah, it's going to be a challenge.
Because what applies, what doesn't. So you make that argument the best you can, and then the judge makes the decision whether or not that old case law. Because if the old case law was originated out of the prior legislation and not out of the new legislation, it's a real interesting question whether or not that case analysis or case precedent applies to the new legislation.
Yeah. And how different are the laws? If the laws are radically different, it's hard to think that case law would apply to a radically different setup in the new law.
That's correct. And that's what's happening in family law. I think that a lot of practitioners and, we're struggling, and a lot of clients as a result of that are saying, okay, we have such major different laws now. Do we apply those old standards or not? And then you're testing them, and it's going to be a long time, I think, before we really get that pendulum to swing in a sense of understanding where we're going to be at. So every time a legislative change is effectuated, it does take some time to see the practical implications of that law. And unfortunately, that can increase litigation by mere fact that a new process is put in place.
That's exactly right. And I will say this, the legislature doesn't really like to whipsaw back and forth with the law. Once we make a new law, we like to see that roll out for a while before we jump in and radically change it again.
Sure.
That's not the way we like to do things. In some senses, it's a somewhat conservative body in the idea of we're not going to change it every year. That's not going to happen. We want things to evolve on a very gradual basis so that people can have some certainty and courts can have the opportunity to work with the law and develop it instead of us just changing it willy-nilly all the time. That's not the way it works.
Right, and then also we want it to make sure that the law gets applied consistently, fairly, and equally across the board.
Absolutely, that's always a goal.
So, it's a real complicated issue, but I think that people understanding the court process, and when you get involved in the trial stages and your attorneys are talking about appeals, it's important to know the distinction between the two.
The proceeding was a legal advertisement from Gwendolyn J. Sterk and the Family Law Group.